Good afternoon, everyone. Welcome to the second lecture for week 11. In this lecture, we'll be focusing on, week 10. We'll be focusing on questions of constitutional interpretation, thinking about another way in which politics really enters into the court despite its claims of being apolitical. So we're going to talk about the importance of constitutional and statutory interpretation, and then thinking about different schools of thought and philosophies of interpretation. So starting with the question of what is judicial interpretation, why does it matter? It's important to remember that appellate decisions, so decisions making by the Circuit Court of Appeals, or especially by the Supreme Court, these are decisions on questions of law, not fact. They're not evaluating the facts of the case, but whether the law was applied correctly or is constitutional. This is where, because of this reason, this is why interpretation matters, because they have to judge the part of what they're doing in making a ruling. The justices are establishing what the law in question means. So, for example, in the case of Massachusetts versus the EPA, the 2007 Supreme Court case, one of the questions, does the Clean Air Act give the EPA authority to regulate greenhouse gas emissions? The court found that it did. That the EPA, that even though greenhouse gas emissions weren't explicitly named in the Clean Air Act, that the EPA is given that authority by that law. Similarly, does the Religious Freedom Restoration Act allow for closely held companies to deny employees health insurance coverage for contraception as required in the Affordable Care Act? Here, the Supreme Court also said yes, that that the Religious Freedom Restoration Act creates an exception in the Affordable Care Act's requirement for contraceptive coverage, right? They're interpreting how these laws interact and what their meaning should be. They also are asking about what the Constitution means. Does the law or executive action conform to the Constitution? And remember, in Article 6, the Supremacy Clause, right, that the Constitution is the supreme law of the land, Hamilton's argument in Federalist 78, right, that the part of that no law that is unconstitutional shall be valid, and that's the whole point of an independent judiciary. Yeah, and so, for example, does the president, a constitutional question might look like, does the president have the authority to prohibit travel from Muslim majority countries? And does this prohibition violate the Establishment Clause of the First Amendment? So first, a question of presidential authority, and then a question of First Amendment protections. In Trump versus Hawaii of 2018, the Supreme Court ruled, yes, the president does have that authority, and no, this act does not violate the Establishment Clause of the First Amendment. These are just examples of thinking about what the court is doing in these rulings is determining what the meaning of these laws are and the meaning of the Constitution is. Now, this matters because the United States, it has what is known as a partially common law system. In addition to kind of statutory law, in addition to laws that are publicly written by the legislature, there's also a body of law created by judicial rulings and opinions, and so the rulings of a court has the power of law. When the court rules that the president has the authority to restrict travel from Muslim majority countries, that is establishing legal authority for that action, right? When the court rules that some law is unconstitutional, they are ruling that that law is no longer legal and valid. So precedent matters. That is the idea that the courts are going to look to how previous courts have ruled on similar questions and generally follow precedent. So court rulings will become case law, and opinions become the bases for future rulings. So the actual act of interpretation matters in shaping what that law is going to look like. And this leads to the doctrine known as stare decisis, let the decision stand. This is the idea that past decisions are binding on the lower courts until the precedent is overruled, in which a higher court finds that the principles in the previous decision are either erroneous or no longer apply because of legislative changes, right? So until Plessy versus Ferguson was overturned by Brown versus Board of Education, right, segregation was constitutionally protected because of that precedent of Plessy versus Ferguson, and it required a higher court, or in this case, the same court, because it was the Supreme Court, there is no higher court, to overrule that precedent, and basically claim that we say we got it wrong, or they're saying that like the law has changed, so that precedent no longer applies. So the court is interpreting the meaning of the Constitution, legislation, various laws passed by Congress and state governments, as well as previous decisions and opinions. So there's lots of interpretation. And even though pretty much every single nominee to the Supreme Court, when they testify before the Senate Judiciary Committee, says something along the lines of, my job as a judge is not to make the law, my job as a judge is to call balls and strikes, this act of interpretation is not neutral. Interpretation always brings in existing worldviews and biases and the manner in which we interpret things, because it's not simply just like reading a number off of a piece of paper, right? An interpretation is an active process where you are trying to make sense of something, that the way that you interpret something, the school of thought that you bring to that interpretation is going to affect how you understand and read the passage, right? And so these worldviews, these schools of thought, what are going to shape, for example, like what information you even look for to interpret, and as we'll talk about in a minute. If you're a textualist, you only look at the text of the law, where if you're not a textualist, you might look at other sources to figure out the meaning of the law, right? And so this is the idea of what's known as the hermeneutic circle, that what we're doing when we're interpreting something is that we're always kind of bringing our own worldviews and our own kind of prior understanding to any sort of interpretive question and any particular thing that we're interpreting. And then we draw conclusions from that, which in turn shape our worldviews for future interpretation. And so you can't really get out of it. There's no neutral kind of like, oh, here's what the law objectively means without any interpretation, without any bias, without any sort of influence, human element, right? There's no such thing as that. So how do we determine the meaning of a law or a constitutional text? Well, there's a couple of different kind of dueling debates, and that often, unfortunately, in legal writing, especially public commentary, get muddled together. So the first is the question of textualism versus legislative intent. What do we look at when we're trying to determine the meaning of a text? Textualism says that the text of the law or the clause in the Constitution itself is the sole authority of its meaning. You do not look outside of the text. You do not look at what the founders were writing when they were reading when they wrote the Constitution. You do not look at the context. You do not look at anything else. You look at what does the text say. Or others, you might look at legislative intent. You look at the history of congressional debates over that law to get a sense of what the legislatures were trying to do when they passed the law, even if and that you would use that intent to clarify any ambiguous phrasings or ambiguous sections of the law, where it's not clear from the letter of the law what the law is actually supposed to mean on this question. For example, waters of the United States, that's super vague. So what you might do is look at congressional testimony and congressional debates and see what the lawmakers were talking about when they were talking about the waters of the United States. Now, often textualism gets conflated with this idea of strict constructionism, that we are going to interpret the literal meaning of the words. And this is often associated with people like former Justice Antonin Scalia, despite the fact that in his writings, Scalia says, quote, I am not a strict constructionist and no one ought to be. A text should not be constructed strictly and it should not be constructed leniently. It should be constructed reasonably, and that means all that it fairly means. This idea of a strict constructionist is usually a kind of a word made up in public commentary that doesn't really have like a legal meaning. Like, what does it mean to construct a text strictly or not? The other kind of the question about, especially when it comes to constitutional interpretation, is this question of originalism versus living document, right? Should the interpretation of the Constitution or a law should that meaning be settled and fixed based on what it meant at the time it was enacted, whether you use legislative intent or textualism? Or should the Constitution or law be interpreted in terms of its purpose and in the context of social change? Should we look at kind of like, well, what were they trying to do? They were trying to expand voting rights. And so that means that we can kind of reinterpret the purpose of this law in contemporary context, for example. Now, it's important that these things are not the same. Textualism does not mean originalism, does not mean strict constructionism. Strict constructionism is a political buzzword, but it's fairly meaningless. Textualism concerns where someone should look for interpreting the meaning of a legal text. Do you look at the text? Do you look beyond the text? Originalism interprets a legal text in terms of its original historical context, right? It's more about like, is the meaning fixed or does the meaning change over time? Textualism is a guide for what you look at when you're interpreting. So, for example, Scalia was both a textualist and an originalist. He believed that you only look at the text and you look at what the meaning of the text would have meant at the time of its adoption. However, you could have a textualism that is not based on originalism. In a 2020 Supreme Court case, Bostock versus Clayton County, in a 6-3 vote, it held that firing an individual for being gay violates Title VII of the Civil Rights Act, even though the text doesn't actually say anything about, even though it can be fairly clear that the Civil Rights Act was not intended to protect to create sexuality, sexual orientation as a protected class here. And Neil Gorsuch, who is a textualist, wrote the opinion for the majority, writing that the limits of the drafter's imagination supply no reason to ignore the law's demands. When the express terms of a statute give us one answer and the extra textual consideration suggest another, it's no context. Only the written word is the law, and all persons are entitled to its benefit. So even if the legislative intent was not to protect people from being fired for their sexual orientation, or protect people against that, given that the text itself includes such a protection, that is what the text law means. So in the kind of video, not reading, but the video assigned for this week, we have this debate over constitutional interpretation. And so Scalia, in his writings, makes a series of arguments for textualism. And again, his position is, as he says in On-Call versus Sundowner Offshore Services, it is ultimately the provisions of our laws rather than the principal concerns of our legislators by which we are governed, that we are governed by laws, not the intents of legislatures, and that when we are making decisions about what the law means, we should look at only what the law says. Why? Well, for him, the text provides a much more clear anchor of interpretation. As he writes in his book, A Matter of Interpretation, when you are told to decide not on the basis of what the legislature said, but on the basis of what is meant, and are sure that there's no necessary connection between the two, your best shot at figuring out what the legislature meant is to ask yourself what a wise and intelligent person should have meant, and that will surely bring you to the conclusion that the law means what you think it ought to mean. The idea here is that how do we know what the legislature meant? Like, ultimately, we can't know. Even if we look at their speeches, even if we look at the legislative history, we can't know what's truly in their minds. And when we start looking beyond the text, we start imposing, well, here's what I think they would have meant when they used this language. And you get this arbitrary basis for establishing what the meaning of the law is, or when you look at plainly just the letter of the text itself, Scalia thinks that you're going to have a much more clear and not less arbitrary basis for interpretation. And his argument here is once you have the courts rewriting the law based on what they think people meant by it, then you can risk a tyranny of the majority. As he writes, if the courts are free to write the Constitution anew, they will, by God, write it the way the majority wants. This, of course, is the end of the Bill of Rights, whose meaning will be committed to the very body it was meant to protect against the majority. By trying to make the Constitution do everything that it needs doing from age to age, we cause it to do nothing at all. The whole point of the Constitution and the Bill of Rights is to protect minority rights, is to protect against the tyranny of the majority in a democracy where if you get 51% of the vote, you can take away people's rights, right? The whole point of having a right is to prevent that from happening. And if the Constitution's meaning is whatever people think it means and as a majority, then it no longer provides this anchor, this guarantor of liberties, right? And this is the kind of principled argument that Scalia is making here. Now we can talk about in discussion section whether or not he consistently applies this, but this is the argument itself. And he makes further argument for originalism, and this should not be confused with an idea about the framer's intent. It is not, as he makes it very clear in A Matter of Interpretation, he's not saying that the intent of the founding fathers gives meaning to the Constitution. He rejects it for the same reason he rejects the idea of legislative intent. And he says that the great divide with regard to constitutional interpretation is not between the framer's intent and objective meaning, but rather between an original meaning, whether derived from framer's intent or not, and current meaning. that the statute should mean what the law should mean what it meant when it was adopted. That is the clear and objective, in his mind, meaning of the statute. So, and again, the argument here is the idea of stability. And the whole point of a constitution, he writes, is to prevent change, to embed certain rights in such a manner that future generations cannot readily take them away. And therefore, if the Constitution is completely mutable and arbitrarily and changing every generation, then it's no longer providing that foundation of rights protections. And he says that the Constitution has its own mechanisms for change, that if you want to expand rights, and you should do so by amending the Constitution, not by changing the meaning of the current text. He once wrote that if you want there to be a constitutional protection for abortion, you should pass a constitution, and there's majorities in favor of that, then the majority should pass an amendment to the Constitution providing that constitutional right, instead of relying on justices to infer a right to an abortion based on an inferred right to privacy from the amendment's protections against search and seizures, right? And in a matter of interpretation, he writes that 75 years ago, we believed firmly in a rock-solid, unchanging Constitution, that we felt it necessary to adopt the 19th Amendment to give women the right to vote. The battle was not fought in the courts, and few thought it could be, right? The whole point was you wanted to, amending the Constitution, is that you want to then create a rock-solid foundation that people will not take, then start denying suffrage on the basis of sex or gender. And so here you can have his kind of principled argument would be, you do not want that meaning to be up to 9 people in robes, because what if they decide 100 years from now, what if 5 of them decide that actually the 19th Amendment only protects, it doesn't actually mean what it means. It actually only protects some women. It doesn't, the right to vote for some women, right? Then you wouldn't then it kind of defeats the whole purpose of having that constitutional right. Now, Stephen Breyer, in opposition, argues instead of what he in Active Liberty, he argues that others look at what the purpose is. How would the person who wrote the law or statute or constitution or whatever would have wanted the court to interpret the statute in light of present circumstances in the particular case, right? Because for Breyer, he's resting on this idea that people are fallible, people make mistakes, that people can't know everything when they're writing a law. And so you look at so the letter of the law might be anachronistic. It might not apply in changing circumstances or in the particular case. And so a reasonable interpretation is not to try to apply the letter of the law anachronistically, but to say, like, what was the purpose of the law based on what were they trying to do when they passed this law, and how, in this particular case, would that same logic apply? And so, again, this is because the text cannot answer all questions. If there's a question about what the phrase means, right, Breyer's arguing you can't look at the phrase itself to answer that question, right? If there's an ambiguous phrase in a law, looking at the law more isn't going to answer the question of what that ambiguous phrase means. You have to look elsewhere. And so he argues that the goal should be advancing democracy. That he says, when we're looking at the a textualist approach to interpreting the Constitution, that's going to undermine what he calls the Constitution's democratic objective. The whole point of the Constitution is that legislation in a delegated democracy is supposed to embody the people's will. And an interpretation of a statute that tends to implement the legislator's will to implement the public's will, and is therefore consistent with the Constitution's democratic purpose. So you look at the majority opinion, how the majority would reconstruct the meaning of this law, because the purpose of the constitutional framework is to respect the people's will. And so he argues that in First Amendment cases, for example, the court should protect forms of speech that actively support the idea of the people's will, right? So, like, you are going to protect free, contestatory political speech, while you can regulate forms of speech that run counter to the people's will, i.e. things like money and politics. So we'll talk about in discussion section, based on you all watching the debate between these two, like which arguments you find more persuasive. Next week, we're shifting gears to state and local governments, looking at chapter 4 in the textbook, and in a kind of a more contemporary example, thinking about the impacts of COVID. The optional reading is a kind of a more speculative reading about how we could reform political boundaries, state and local government boundaries, to better respond to the reality that states seem to be increasingly anachronistic. So that is it for this week. The minute paper question, again, you can go to bit.ly/Pauls101. And what is judicial review, and why does it raise questions of interpretation? Explain what judicial review is and why it raises questions of interpretation. That's it for this week on the courts. I will see you next week when we talk about state and local governments.